Discharge of contract. Discharge of contract. So everything that has a beginning shall definitely come to an end. So when parties enter into a contract, the contract does not always last forever, at least in most cases. It is it's usually designed in a way that there would be a point where parties perform their contract and their contract come to an end. Even if they didn't perform their contract, contracts can also be discharged by other ways. For instance, contracts can be discharged by performance, contracts can be discharged by breach, contracts can be discharged by agreement and by frustration. So when we say discharge of contract, it simply means that the contract has come to an end. It means that the rights and the obligations which the parties agreed upon, when the contract was formed, have come to an end, and the parties are released from their duties, from those obligations that they entered into when they entered into the contract. So, but in this recording, we're going to be discussing just discharge by performance. Then the other one would discuss the other forms of discharge. So discharge by performance simply means when parties fulfill their contractual obligations precisely and completely according to the terms of the contract. A party who has performed all of his obligation in a contract is discharged, right? And can bring an action in court against the other party who has failed to perform his obligation. So you know that in contracts, there should usually be at least two parties, at least, right? And both parties, when they enter into the contract, they assume duties and obligations, and each party, as they're assuming duties and obligations, they're also conferring rights and, on the other party. So a party who has performed his own obligations, his own duties, his own undertakings, is discharged from the contract. If the other party also performs his own obligations completely and precisely according to the terms of the contract, then he is discharged or she is discharged from their obligations. So before we go deeply into discharge by performance, it's important that we understand order of performance. So what does order of performance means? Order of performance simply means the sequence for performing the transaction, the contract, right? Who should perform first? Who should perform first? And who can bring an action if one party has not performed, right? In most contracts, the parties are not required to perform at the same time. So in some contracts, not in most, in some contracts, parties are not required to perform at the same time. Rather, one party, must perform first, and then the other party would perform second. This, you can find that in an example for a transportation contract. right, in an Uber or an air transport, right, you would find that it could be that the passenger would need to pay for the tickets first. They'll need to perform their own side by paying for the ticket first. Then the transportation company would perform their own by transporting the passenger. You can also find, another example in construction contracts where the first person to perform might be the person who the party who contracted the construction company or the the contractor, right? And in such a case, it might be that that party might need to provide mobilization fee or cost, might need to pay money for the materials for the building. And then the contractor now has the obligation to construct, and the other party now has the obligation to maybe complete the payment. So you see that in some cases, not in all cases, there is an order of performance who performs first, followed by the other party. So the order of performance is usually determined, from the construction of the contract, from the terms or the nature of the contract. We've already talked about if it's a construction contract, there might usually be mobilization fee. If it's an employment contract, there might even be some sort of fee that is to be paid first. And in some cases, there might not be. It might just be that the employee needs to start work first, then the employer would pay at the end of the month. So in such a case, you can see that now the employee has the duty to perform first. The employee's duty is to be performed first, and then followed by the employer's duty. So where a party's obligation must be performed before the other party's obligation, right? Let me give you an example. Where party A is to perform an obligation before party B, right? So before party B's obligation can become due, the order of performance in this case is that, party A has to perform first, followed by party B. And that if party A defaults in performing, party B can sue to enforce the contract, even though that's party B, has not performed his obligation. So order of performance, as I already said, is the sequence in which the contractual obligation is to be performed. That sequence can be stated in the contract, right? Or it can be inferred from the nature of that contract. So for a party to be able to sue, he has to show that he has either performed his obligation or the order of performance, is not yet his turn to perform. The other party was supposed to perform first. That is, his own duty to perform has not yet arisen, So if party A, performance is like a condition precedent, right? Then party B can sue party A if he doesn't perform. So you see that example I gave you, the scenario I painted with party A and party B. Party A is to perform first and then followed by party B. Party B's obligation to perform is what we refer to as condition precedence. So condition precedence is when a party has that first obligation to perform. And where the obligation to perform, must happen simultaneously in order for the contract to be discharged, right? Neither of the parties can sue to enforce the contract unless he has performed his own obligation or unless he's ready to perform his own obligation. So this sort of arrangement now is referred to as concurrent or simultaneous obligations. Remember that we talked about condition precedence. Condition precedence is when one party needs to perform, right, before the other party. and that person whose duty is to perform, yeah, that his obligation is referred to as the condition precedent. So in that case, Party A, who has the duty to perform, cannot sue Party B for not performing because he or she has that duty to perform first. But Party B, whose duty has not yet arisen, who is probably waiting for Party A to perform his own condition precedent, can sue Party A if Party A does not perform his obligation. That is when, there is a condition precedent. But when the obligations are concurrent or simultaneous, right? It means that, any of the parties can sue to enforce the contract. But then for a party to sue to enforce such a contract, he must show that he has performed his own obligation or he is ready to perform his own obligation. And you would find that in general sale of goods contracts, where you're selling your pen and I want to buy it for 50 naira or for 100 naira. And there is nothing in the contract that says, I should deliver I should pay the money first before you deliver, or that you would deliver the goods first and I will pay in tomorrow or next 2 weeks, right? If there is something in the contract that says that, then that is a condition precedent. It's been stated by the contractual terms. However, if there is nothing in the contract that states the condition precedent or that states the sequence of performance, then in such a case, it's referred to as simultaneous or concurrent because the parties are expected to perform irrespective of who will perform first or who will not perform first. And in such a case, before the buyer can sue, he needs to show that he has either paid or he is ready or willing to pay. Before the seller can sue the buyer for not taking delivery, he has to show that he has either delivered the goods or is ready and willing to deliver the goods. Then the third case is where the obligations of the parties, where the obligations are independent. This is where the parties can enforce the other party's obligation, irrespective of whether he has performed or whether he has not yet performed his own obligation. An example is in landlord tenancy agreement, where they have already entered into the tenancy agreement. I would lease this house to you or this flat to you for a period of time and you would pay this rent. And as the landlord, I undertake to do this and to do that and to do that one. Irrespective of whether the tenant has paid or not, the landlord's duty still stands, and the landlord has a duty. Maybe if he has already, undertaken to do repairs, he has that duty to do the repairs. Except the tenancy agreement specifically states that, the tenant has to make a payment first before the landlord can perform his own obligation. But in such a contract, it's usually independent of the other party's obligation. Okay, so now back to the entire performance rule. when the parties perform their obligations, as I said earlier, they are discharged from their obligations, right? When they perform what they have promised to do, they're discharged. And, if there is no dispute, if there is no issue, then they can just go about their business, without another person suing, one of the parties suing the other party. But that is not always the case. That's not always the case. Disputes could arise. Disputes do arise whenever there is a contractual relationship between people. There's a likelihood that there might be disputes with respect to whether the contract was performed at all, whether the contract was performed according to the terms of the contract, precisely and completely according to the terms of the contract or not. Whether, one of the parties have performed their duties or satisfactorily, or not. So one of the parties could claim that he had performed his obligations and should now be paid his, what the other party undertook to pay. And the other party could say that he did not perform his obligations at all, or he didn't perform it within the time he was supposed to perform it, or he didn't perform it accordingly, he didn't perform it satisfactorily according to the terms of the contract. The argument could also be that I tried to perform, but you did not allow me to perform, right? And so when these disputes arise and it gets to court, the court has to determine whether the obligations of the parties, whether the parties have discharged their obligations and whether, they have performed their obligations and they are discharged. The court has to determine, whether the obligations in the disputes or in the contract has been performed or not, and whether the party seeking payment, should be paid. So irrespective of, in relation to the performance, right, contracts can be grouped into entire contracts and severable or divisible contracts. So entire contracts are contracts where the lump sum of the consideration or the price is to be paid at the completion of the entire work, right? Entire contract is where a lump sum of payment is to be made at the end, at the performance of the entire contract. It's not to be divided, right? Example is a construction contract, or no, let's not say construction, let's say employment contract, where an employer contracts an employee to work for him or her, and the employee is to work and be paid at the end of the month after the work for the month is completed. Or where a contract of sale of goods or even the delivery of services, and payment is to be made after that work has been completed. You're supposed to sweep my office, you're supposed to fix my laptop, or you're supposed to deliver a tablet or a car, and payment is to be made as a lump sum, not to be broken into portions or parts, right? But to be paid as a lump sum at the end of the contract. That is referred to as an entire contract. A divisible contract, on the other hand, is the opposite of an entire contract. This is where the payment is to be made, has been divided into parts, right? Payment is to be made at the completion of each of that part of the contract. For instance, you're supposed to perform certain obligations. I contract you, you are a photographer, and you're supposed to take pictures. You're supposed to work for me for 1 week. Every day you're supposed to do something different. Every day you're supposed to do something. And at the end of that duty, I'm supposed to pay you. For instance, you're supposed to work for me for a week, and you're supposed to deliver a photo book, a video, a content, pictures, and what else do photographers deliver? and frames, right? And after each work you perform and you deliver, I'm supposed to pay you an amount of money that's been agreed by both of us, right? And you take the pictures and you send them to me. I pay you. You take another picture, you do the video or the pre-wedding shoot or whatever it is people do these days, or the modeling pictures, I pay you. You produce a video, I pay you. You produce the photo book, I pay you. You produce the frames, I pay you, right? And you can see that the work has been divided into parts and payment is to be made at the end of each of those parts. It's different from if it was an entire contract where you are supposed to do all these things. And at the end of the contract, at the end of when you have performed all those obligations, I pay you a lump sum. It's not been divided into parts, into smaller parts. So an entire contract is different from a divisible contract. And there is the general rule in common law with respect to entire contracts. And that general rule is that a contracting party who has not performed the contract exactly and precisely according to the terms of the contract shall not be entitled to remuneration. So if the contract is an entire contract, right, and payment is to be made at the end of performance, and that performance has not been done, or the obligation has not been performed precisely and according to the terms of the contract, then the general rule in this case is that that party is not entitled to remuneration. And you would see that in the case of Cotter and Powell, and in the case of Sumter and Hedges. So in Cotter and Powell, what happened in that case is a 1795 case, but it's a locus classicus for entire contract, right? What happened in that case was a seaman was contracted to serve on a ship that was sailing from Jamaica to Liverpool. And he was supposed to be paid 30 guineas at the completion of the voyage. So the terms of the contract stated clearly that that was an entire contract, that his payment was to be made as a lump sum at the end of the voyage. However, he died, at sea after having served for about 7 weeks out of 10 weeks. So he still had like 3 weeks outstanding, but he had served for 7 weeks. And so his widow brought an action in court. In fact, his widow tried to recover the wages that he had for the portion of work he had already done. And the employer refused, and they went to court. And the court held that the contract was an entire contract. It was an indivisible contract. And that the continuous service on the ship for that entire journey was the condition precedent for the payment. Therefore, the plaintiff was not entitled to any pay. So although this entire performance rule is the general rule, is not absolute. Because the Cotter and Powell case actually brought into view the hardship that a strict appliance of this general rule can bring to parties. So, courts have over time developed qualifications, not exceptions, qualifications to this rule, this entire performance rule. And, it was developed to be able to mitigate the hardship that was caused by the rigid application of the entire performance rule. And also to limit the fact that the party who has enjoyed 70% of the contract, would have to enjoy that contract without having to perform their own obligation, without having to pay anything at all. So that was like unjust enrichment of that party, because the party will retain the benefit that they've already or that they've partially enjoyed, or that has been partially performed, and not the performance, and without having to make any payment at all. So that was really unjust. And so what has happened is that to mitigate the hardship, the court developed certain qualifications to this rule. And the first of those qualifications is what is referred to as substantial performance rule. So the substantial performance rule happens where a party has not performed exactly and precisely according to the contract, has not performed fully what he promised to perform, but has performed a substantial part of that contract. So that the general respect to entire contracts is that if you've not performed exactly and precisely, you can't be entitled to remuneration. But then the substantial performance rule states that if you have performed a substantial amount, a substantial amount of that contract, you are entitled to payment, right? Minus, or you're entitled to payment less or minus any amount that the other party would have to spend to be able to remedy that defect, to be able to complete the work or to remedy the defect. Then the injured party, also is also entitled to bring an action for damages for any loss that he may have sustained. But then it's not like the entire performance, the general, the entire performance rule that the injured party gets to keep the partial performance and does not need to pay. Under substantial performance, the injured party, has to pay for the contract, but then the injured party has to subtract the amount that they need to be able to remedy that loss, to be able to, the defect, to complete the contract or to remedy the defect. So you would see that in the case of Honing and Isaac. So what happened in that case was that the plaintiff, was an interior decorator. The plaintiff was an interior decorator, right? He was a furniture designer. So he had performed the contract. The contract was worth £750. Payment was to be made in 2 installments at the start of the work and at the completion of the work. So at the completion of the work, the defendant refused to pay the complete amount, claiming that the plaintiff had not properly done what he undertook to do, that there were defects, it wasn't done, satisfactorily. So the plaintiff brought an action for payment of the balance, less the cost of fixing the defect, and the court decided in the plaintiff's favor. So now the question now is what amounts to substantial performance? What would the court usually interpret as a party having performed substantially? So to be able to determine whether the performance is substantial or not, right? The court, you would usually look at the terms of the contract. We usually look at the facts of that case. So it's not like the court looks at it on a case-by-case basis. So it's not like there is a one fit rule that applies to all contracts. But then the substantial performance rule does not apply to conditions, right? So if there is a condition, I'm sure you remember what a condition is. A condition is that the term of the contract that is so important that not performing the obligation goes to the very roots of the contract. If it's an obligation, if it's a condition, then the substantial performance rule would not, apply. But it applies where the duty that has been breached, the duty that has not been performed completely and precisely, is a warranty, is not a condition, where it's an inferior, where is the term that does not go to the root of the contract. Then the next one is acceptance of partial performance. Acceptance of partial performance. A party who has not performed a substantial part of the contract, yes, but has performed some part of the contract, and that partial performance has performed was accepted by the other party, then the party, the injured party, has an obligation to make payments, to pay the party in breach on a quantum merit basis. So a party who did not perform his obligation substantially, you know that the first rule we talked about was entire performance. You're supposed to perform entirely. You're supposed to perform according to the terms of the contract, right? But then substantial performance says if you didn't perform according to the terms of the contract, precisely according to the terms of the contract, you can still be able to be paid, right? Because you perform substantial amounts. But then this second rule, this second rule now, right, simply says that if you did not perform substantial amounts, you did not perform substantially, but then you performed partially, right? What you performed is not substantial, but it's partial. And the party at the receiving end accepted your performance, then the party who did not perform substantially, is entitled to claim remuneration for his labor and for materials on a quantum merit basis. Quantum merit basis simply means you're going to be claiming according to the work you have done. So if you've done work for 3 days out of 10 days, you'll be paid for the 3 days. If you've done for 2 days or 5 days out of 10 days, if we are to look at a contract, generally, someone who has done 3 days or 4 days or 5 days has not performed substantially, but has performed partially. But then for a party who has performed partially to be entitled to remuneration on quantum merit basis, the party, must have accepted that partial performance. According to Section 30, Sub 1 of the Sale of Goods Act, right, where a seller delivers a quantity of goods less than he had contracted to sell, and the buyer accepts them, he must pay for them at the contract rate. He must pay for the ones he accepted. He must pay for the goods at the contract rate. So when we talk about acceptance, what does acceptance really mean? What does acceptance really mean? Section 35 of the Sale of Goods Act provides that acceptance can be expressed or implied. Acceptance can be expressly, expressed, when you convey that information in words, either written words or oral words, right? Or even when you, by your actions, when you accept it, right, expressly, you can't go back and say, well, you didn't perform according to the terms of the contract. It can also be implied from your conduct, right? And Section 35, goes ahead to describe what acceptance means under the Sale of Goods Act. The first one is when the buyer intimates the seller, informs the seller that he has accepted the goods. That is express, right? The second one is when he does any act which is inconsistent with the seller, with the ownership of the seller. So if the seller delivers goods that are not up to the standard that was agreed, but then the buyer takes the goods, right? Informs the seller, I have accepted the goods. Then Sale of Goods Act says, you can't go back on your words. You have accepted is that you've accepted, right? But then even if he doesn't intimate, he doesn't communicate acceptance to the other party, but deals with those goods in a way that, is inconsistent with the ownership of the seller. For instance, he takes the goods. He doesn't communicate, right, to the seller. Rather, he takes the goods and he sells to somebody else. You see that he has dealt with those goods in a way that is inconsistent with the ownership of the seller. Or he takes the goods, gives it to his tailor, who cuts it up and sews it. So even though he has not communicated acceptance, his action has shown that he has accepted the goods by dealing with those goods in a way that is inconsistent with the ownership of the seller. Then the third one is if he retains the goods after the lapse of a reasonable time. If he keeps the goods, he doesn't return it, he doesn't communicate, he just keeps the goods with him after the lapse of a reasonable time, then the Sale of Goods Act says that he has accepted those goods by his actions. So what the court will determine as a reasonable time for one case might be different from what the court will determine as a reasonable time for another case. So what the court usually looks at is, if it's a perishable goods, yes, the court will look at, what the court will consider a reasonable time would be shorter than what the court will consider a reasonable time if it was not a perishable goods. In the case of Omoleye and Okeowo, the seller delivered a fabric. In fact, he delivered a different fabric from what was agreed upon. In fact, the fabric he delivered was even more expensive than what the parties agreed to contract, what they both agreed to buy and sell. However, the buyer took delivery of the goods and sold them. And the court held that the buyer had accepted the goods, because when he sold them, he dealt with those goods in a way that was inconsistent with the ownership of the seller. And so he has already signified by selling the goods that he has accepted those goods. So, the seller was entitled to payment for the fabric. But then, he was entitled to payment for the fabric, but not at the higher cost. As I said, the fabric that was delivered was more expensive. But then the court held that the seller was entitled to payment at the stipulated price, at the price that was stipulated, that was agreed by the parties in the contract, not at the higher price. So for a party in default to be able to claim to have, to be able to claim to be discharged under this qualification, right? The acceptance of the partial performance must be voluntary. It should not be forced. And it should not be, you should not take away the option of the other party. So it should not be forced. It has to be voluntary. For instance, if the party had the option to reject the goods or to reject the service, but did not reject it, right? He's not forced. He had that option, he didn't exercise that option. But then if the other party did not have the option to reject the goods, for instance, if, like in the case of Costa and Powell, right? They didn't perform. Let's say that the performance was not even substantial. The performance was probably partial, and the other party accepted performance, right? In such a case, in fact, the other party cannot accept performance because the defaulting party died. he didn't have an option to reject the partial performance. He had to accept it because he didn't have an option. The other party died. So in such cases, it won't be considered acceptance of partial performance because the other party did not have the option to either accept or not accept. It wasn't voluntary. Then the other qualification is wrongful prevention of performance. So a party who would not otherwise be entitled to remuneration may still be able to claim remuneration for work done on quantum merit basis, where the party who was already performing part of his obligation, was prevented from completing performance of that obligation. So wrongful prevention of performance happens when a party who has already started performing, was prevented from completing the performance, was wrongfully prevented from completing performance by the other party. For instance, where party A prevents party B from performing, and party B is discharged from the contract, and he can claim remuneration in such a case. But then where performance relates to money, right? Prevention or rejection of the money does not discharge party B from his obligation in the contract. He will still need to pay. But if it's not with respect to money, then, wrongful rejection or prevention of performance can actually discharge a party and entitle that party to remuneration. Then another qualification which is very similar to wrongful prevention is tender of performance. So tender of, that wrongful prevention is that a party has already started to perform, but was prevented from completing performance. Maybe he had already started, constructing the building if it's a construction contract, but then, he was not allowed to complete the contract because the other party locked the gate, or because the other party refused to give him access. Or let's say even the photographer we talked about earlier, had already started performing, but could not complete because the bouncers at the door, the bouncers that were acting on behalf of the other party, refused him from coming into the premises or into the event to even take the pictures. But with respect to tender of performance, this is where a party offers to perform. When a party offers to perform, that's referred to as he has made a tender. He has tendered to perform. So it could be where a party makes an offer to perform an act, or where a party makes an offer to make payment. And the way the two are treated are different. Where a party makes an offer to perform is different, is different. The rule with respect to where a party makes an offer to perform an act is different from the rule where the party makes an offer to make a payment. If the tender is with respect to performance of an act, right? For instance, with respect to delivery of goods or services, and he's wrongfully refused, delivery of those goods, the duty to perform is discharged. He's discharged from his duty to perform. And, the tenderer is released from his obligation to perform and may either bring an action to claim damages or use, he could actually use that rejection as a defense if an action is brought against him for breach of contract. An example of this is Startup against McDonald's. So a contract, the parties entered into a contract for the delivery of oil, and the contract provided that the oil was to be delivered anytime at the end of March. So the plaintiff attempted to deliver the oil on the 31st day of March, that's the last day of March, at 8:30 p.m. So the plaintiff, attempted to deliver the oil, right, at 8:30 p.m. on grounds that, at the premises of McDonald's. And then they rejected, delivery of the goods on grounds that he was delivering, late, that the hour of delivery was late. But the court had to interpret, the contract. And the contract actually said he was to deliver the oil anytime at the end of March. And, the court interpreted that to mean that he delivered within the time he was supposed to deliver, because as of that time, the company, the McDonald's, the defendant, was still open for business. And so the court held that, the other party, the plaintiff, was actually discharged from the obligations because they were wrongfully prevented from delivering the goods, the oil. However, where the performance is with respect to payment of money, right, and the other party fails or prevents one of the party from performing, from paying the money, such prevention does not discharge the debtor of his obligation to pay. So although the party who, the debtor, does not need to make another tender, does not need to make another offer to pay, but is expected to keep that money, right, ready to make payments of his debt. He's not expected to go home and sin no more. He's expected to still keep that money. He will still need to make the payments. So for a tender to be valid, right, that amount of money that he was going to pay, right, must be the exact, precise amount of money, right? It can't be anything more, it can't be anything less. So the tenderer must also be able, to show that, must be able and willing to perform immediately. He must be able to show that he is willing and able to perform immediately, if allowed, or if given, the access to perform. So if it's with respect to money, if it's with respect to money, the tenderer must show that he actually has the amount of money that he needs. He must actually, he must be able to produce that amount of money. So he's supposed to produce the amount of money. He must also be able to, he must also be able to show that he made, he made the tender at the proper time and place, and in the manner that they both agreed, and that the buyer had a reasonable opportunity to inspect it. So the difference between wrongful prevention of delivery and tender of performance is that in the wrongful prevention, the party has already commenced performance, as I said earlier. But in prevention of, in tender of performance, right, the party had not yet performed. He's only offering to start performance. In wrongful performance, he had already started. He was only prevented from completing performance. So in common law, where time is of an essence, where the time, in fact, in common law, where the time has been fixed by the parties for performance of the contract, right? That time that's been fixed by the parties for performance, that time that's been agreed by the parties for performance is referred to as time being of the essence. So where time is of the essence in contract, the contract can be terminated if it's not been performed within the stipulated time. The aggrieved party can sue for breach of contract. So if the parties agree that you will deliver the goods on the 31st day of March, right, at 5 a.m., time in such a case, because the time has been fixed, time is said to be of the essence. And if a party does not deliver the goods exactly as agreed within the stipulated time, then that party, can the aggrieved party, the other party can sue for breach of contract. However, in equity, the rule is more relaxed. Where time is of the essence, the party who did not perform the obligation exactly within that time which has been fixed by the parties, does not automatically get discharged. It does not, automatically give him a right to terminate that contract. If that contract can still be performed within a reasonable time without causing injustice. So where parties did not expressly state the precise time of their contracts, right? But then it can be inferred from the nature of the contract that time is of the essence. Then time is of the essence. Then the rule also applies with respect to time. For instance, where the goods to be delivered are fresh goods, are perishable goods. Typically such a contract would be said it would be said that time is of the essence. So even if the parties did not specify a specific time for delivery, in such a case, right, time would be said to be of the essence because the goods could perish anytime. So the notice, does not need to be extended. It can be very short. So in the absence of a specification of time, performance must be rendered within a reasonable time. And as I said earlier, what a reasonable time is open to interpretation by the courts on the basis of or based on the circumstances and the facts of that case. And so we've been talking about entire contracts, right? And we said that the opposite of entire contracts are severable contracts or divisible contracts. And we've talked about the general rule. I hope you remember what general rule is and the qualifications of those general rule. So now with respect to severable and divisible contracts, if one, I've already defined that these are contracts that have been divided into distinct parts, and each part is to be paid for. Consideration is, performance is to be, consideration is to be paid or to be made after the performance of each part, not at the end of the entire contract. So consideration for each stage of performance is to be completed or is to be made at the end of each stage. So in such a case, right, where the performance is put in parts and payment is also agreed in such parts, payment, even if a party did not complete payment, right, is supposed to be paid according to the part that he has performed. So that general rule with respect to entire performance does not apply in this case. So the payment is to be prorated for each portion that he has performed, independent of the performance of any other part of that contract. So, with respect to divisible contract, the entire performance rule does not apply, if it's a divisible or severable contract.